Heidi's here.
Okay, good. I think last time I asked Ms. Entler to do a UA. I didn't see the results in the file, but has that been done?
Yes.
Okay. And the results of that?
They were cleaned.
Okay, good.
They look good. Yes.
Glad to hear that. I see that the case has been set for trial the week of June 26th. Do we need to make any adjustments before that trial date? And what's going on right now?
Well, the family has made some adjustments on their own this past week.
Okay.
Two of the children, Tanisha and Cadence, have moved in with their father. Things came to a bit of a head at mom's house, and the children, were given the option of either staying with mom or moving in with dad. And two of the kids chose to stay with mom, and two of the kids chose to move in with dad. There's been a little bit of a hiccup in getting the kids to school. Dad does not have a license or an automobile, and they're out of district, so they have been out of school this past week. Dad has transportation. I believe the bus is scheduled to come on Thursday to pick them up. I believe he's gone to pick up some homework for them so they don't get too far behind. I believe Tanisha has a Chromebook, so she can get some homework and, stay somewhat up to speed, but that's been a little bit of an unexpected transition.
Right. Mr. Entler, can I talk to you a moment? Where's Mr. Entler? All right, Ms. Entler, it sounds like everybody agreed to this change. Is that right?
Yeah, we were gonna do it to where, like, for the two girls that he has 50-50, because I'm still taking them to the doctor's appointments. I do see them and I get them like on a regular basis.
Okay. Did they discuss to you what the visitation would be with the children with the other parent?
No.
Okay. Well, I will note the change that's been made with that. I think this is, go ahead.
Can we put in there, so Tanisha and Cadence both have counselors and peers, and I need to see if we can get it court ordered that they still attend in services. And because Core will not go over to his house because he's making a stink about it unless it's court ordered.
Okay. Mr. Entler, are you with us? They've been attending those sessions already, isn't that right?
They were when they were with me, but it got put on hold. So on Friday, when Tanisha's peer had called me, Tanisha let Chris know that I was sending him over there to see her, and his response was, "Why is she sending him over there?" So I need to see if there's a way we can get it to where, like, they can still be in services and not, their counselors and stuff not having an issue going over there and grabbing them for their appointments.
Okay. I will enter an order to that effect. All right. Anything else I need to know or we need to decide today? It does not appear. All right. So there will be coming up in June a readiness hearing, and then your trial date is set for the week of June 26th. So be ready for that. Okay. Austin Blacklaw here. I see him. Is Dakota Myers here? Dakota Myers. I think given the decisions that we may be making today based on Ms. Turnbull's report, I'd like to give Ms. Myers an opportunity to be part of the hearing. So I understand you need to go to Clark County. So I'm going to hold this case then. Probably.
Well, she says in the chat, it says you have to unmute me. It looks like she's here.
Okay. If you can hear me, you need to unmute yourself.
She said it says the host has to.
See if I can find where she's at. Ms. Myers, there should be a microphone or something on your screen that you can.
She's able to respond in the chat if you can see that, Your Honor.
Yeah, I did see that. So she indicated that the computer's telling her that I need to unmute her, but I don't have that ability. So, Ms. Turnbull, why don't you go do the Clark County case? Ms. Myers, I think what you need to do is completely leave the meeting and then come back in. And then when you come back in, I think we'll figure out the.
Yes, Kyle Lopez is here.
There you are. Good. Okay. And I believe a motion for contempt that was brought by Mr. Lopez. And so do you want to address that? We continued this twice. So this is now the time to address that motion and go forward.
Yes, so just long and short, have a parenting plan and she does not obey it whatsoever on several matters. This child daycare provider, that's a joint decision making, and she's through her mother that, and I've said several times that I do not agree with that. He needs interaction. He needs to go to an actual daycare. He needs to be involved with other kids. Grandmother's house for 8 hours of the day. Another one is pick up and drop off. I work a very flip-flop schedule, so I'm not always able to pick up my son. And so when I work 2 to 10, I have my mother and my girlfriend, or my father and his girlfriend pick him up. And lately, Mauricio, my son, he's been throwing these little tantrums that he doesn't want to go. And keep in mind, he doesn't talk, like he talks very little. And Juanita encourages him, like tells him that you don't have to go, blah, blah, blah. And then she tells them that she's not going to do pick up and drop off unless it's with me. And in our parenting plan, it doesn't say that, she has that right. It's if it's scheduled my day, that my third party is able to pick them up as long as she and my son are known to that. So there's just a lot, like I don't even want like drama. I just want this woman to follow the parenting plan. I can go on and on with the list. He has he's enrolled, he's an active Cowlitz tribal member. In our parenting plan, it is also joint that I'm able to call and get information on him or see the GWE, like the payments that he gets. And
I'd have to object at this point. I don't think that was contained in the motion itself.
All right, I'm going to sustain that because it was not part of the motion.
all right. No worries.
You also indicated that this friend drives by your house.
Yes.
Okay. And that she talks to you during pickups and drop-offs. And I take it that should be limited to just issues dealing with your son.
Correct. Yes.
Okay.
As of right now, we talk through a parenting app. It's like $10, $14 a month, but I mean, it's kind of pointless if she's just going to talk to me at every drop off and pick up.
Did she say when you get together?
What's that? Sorry.
What does she say when they're during the drop-offs?
Just like if I forget a clothing or something, she asks where it's at, or just stuff like that. Like it's not too much of a problem, but we're supposed to follow this piece of paper, this parenting plan. Basically, I just want the days that I'm scheduled to have my son and I'm not able to pick him up. I would like if we could follow the parenting plan and that he can go with my father or he can go with my girlfriend. He's very well known to them and he loves them. It's just lately that he's been throwing these little tantrums and that he doesn't want to go. And it's probably because he has this big iPad in the car and he doesn't want to leave it. He's 3 years old and he cries for a minute. And then once he gets in the car and Juanita leaves, he's totally fine. He has the time of his life.
Okay. Ms. Gilmore?
Just briefly, Your Honor, again, Megan Gilmore on behalf of the respondent non-moving party, namely Juanita Friend. Petitioner brings this motion on several issues in violation of the parenting plan. Just for the record, I wasn't sure if the court received the recent reply declarations as well as the video. Is that being considered today?
Well, he hasn't referred to the video. I'll say that I reviewed it. However, I'm anticipating an objection from you on the video.
Exactly. I wasn't sure if the court was even presented that. So yes, I'm objecting to that. I'm asking the court does not consider that for several reasons. It wasn't many of these allegations were not contained within the underlying motion. My client didn't have the opportunity to respond to them. Obviously, the recording was made without my client's knowledge. I received it yesterday, so I haven't frankly even been able to speak with my client regarding that, let alone respond to whatever is within the video. So we're asking that the video isn't considered. We're also asking that the reply declarations aren't considered. Again, I received them yesterday. They're over page limit, and they contain numerous new allegations that were by individuals that were frankly not submitted within the motion. So we are asking the court does not consider that information.
Mr. Lopez, any response to the objection to the video and the recent declarations that were filed on your behalf?
Video. The reason why that video is like brought forward is because it's an objection to her saying that my family is yelling and being so physical at these parents. She's done this. Like we have police reports of previous times of her doing this, but this is the only time that we've had a video of the exchange going so totally different than how she stated it went.
Well, I have to say that, frankly, again, I received this yesterday, but I'm concerned that we don't have the entirety of the video because conveniently his girlfriend screaming at my client wasn't within the video. So the full picture of the exchange, we don't believe is provided to the court. And again, my client didn't have the opportunity to respond. And again, frankly, it's illegal to record my client without her consent. So I don't understand. This is a motion hearing. Videos typically are not considered, and obviously they would need to be timely, and my client should have the ability to respond to them.
Your Honor, in the video, you could see her boyfriend in the passenger seat, and he's recording as well. So I'm sure.
A ruling on the video under RCW, which is our code system, and the number is 9.73.030. Basically, that statute says that if you're going to videotape somebody, particularly with audio, you need their consent. We are what's called a to-consent state. It's clear that there was not consent to the video. It was taken from the vehicle. I don't know that Ms. Friend even knew that she was being videoed at the time. And then if you go to RCW 973.050, it makes clear that if there's a violation of 030, then you cannot use the video in any civil or criminal proceeding. And so based on that, I'm going to have to exclude the video. There's also an objection to the declarations. I'm going to deny that objection, and I'm going to allow the declarations. Okay, Ms. Gilmore.
Moving forward, a final parenting plan was entered in December of 2022. My client explains in her declaration that she has worked nights throughout the pendency of this highly litigated case, as well as has continued to work nights since this case was finalized. My client's mother has always watched the child overnight. There's simply no change of the daycare, as no daycare services are provided between 7 p.m. and 7 a.m. Petitioner is very aware of my client's schedule, and we believe that this action was brought to simply harass her. There's been simply no change or decisions made regarding daycare. Looking to the address, my client address has not changed since we provided his prior counsel notice. Petitioner brought this contempt action based on a YMCA receipt that referred my client's old address with her parents. Is confirmed within the attached text message. My client informed the petitioner that this again was an old address and that she in fact had not moved. And that, again, he brought this action regardless. There's zero evidence whatsoever within the underlying motion that my client ever stalks or harasses petitioner. There's no specific dates or any sort of specific allegation that she's driving by or having inappropriate conversation. Frankly, historically in this case, there's been the exact opposite. There was a protection order in this case previously against father. My client lives in Lewis County, and her mother and doctors live in Cowlitz County. If there's any sort of driving by, it's because she's in the local area. But again, she has no intent to stalk or harass. I don't think that there's any sort of evidence to support a willful intentional violation. And so we ask the court to deny relating that. Lastly, the parenting plan requires that any third parties that exchanges must remain in the vehicle and not communicate with other party. The person must be familiar with the child. As explained within the declaration of my client, on March 10th, my client went to the exchange location on time. My client attempted to exchange a child, but he became distraught. At that point, petitioner's father became frustrated and threatened my client by alleging that she was going to call the police. My client subsequently informed petitioner that she was going to provide him the child. He refused, and so he missed a day of visitation. He subsequently made zero efforts to request makeup time, which my client would have been willing to do. And she was willing to frankly give him a visitation that day, but wasn't going to be harassed and have verbal arguments with her father in front of the child, who was already upset. Similarly, on March 7th, my client again was timely to the exchange. Again, this is not an individual that's willfully intentionally violating court order. She's showing up to the exchange location. She's showing up timely. She's getting the child out of the vehicle. And then subsequently thereafter, petitioner's girlfriend becomes again frustrated because the child's crying, gets out of the vehicle and yells at my client. My client subsequently puts the child back in the car because she's not going to have a fight with petitioner's girlfriend in front of the child. She notifies petitioner that she's willing to exchange with him directly, and then she subsequently does so. So he doesn't lose out on any sort of visitation in this case. So what you see here is frankly petitioner bringing a motion with unclean hands, as we believe that his third parties are in fact violating the parenting plan, which is resulting in my client's actions. My client showing up to the exchange timely, she's attempting to make this change. And these third parties have, as they've historically done, if the court looks at the history of this case, are causing fights. So we simply ask that the third parties are limited, not because my client's trying to make this difficult. Again, she's trying to make these exchanges occur. She just doesn't want to have fights in front of the child because he's already distraught and clearly to a degree unfamiliar with these individuals if he's having such reactions as confirmed within my client's third-party declarations. So we don't believe there's a contempt in this case. We don't believe that there was basis to bring a contempt, and we ask the court deny the contempt and award fees to us for having to respond.
All right, Mr. Lopez, any response to that?
Yeah, I'm just in awe pretty much. My son is very well known to all my family, so I don't know how someone could just speak on that behalf and say that, you know. I don't have anything besides pictures and just good memories to show and say otherwise, you know. Mauricio has a very good supportive system on our side of the family, and pickup and drop-offs, she is showing up, and I'm showing up, my third party's showing up, but she's not following through with having him come with us. And I really don't know what else to say on the part of their allegations of saying that my third parties are creating these scenes, because the only thing I have is that video to say otherwise. But my family is very respectful. They've been through the system before, and I'm here representing myself today because I simply don't have the money to have someone speak for me or prove things. So I just really hope that you take my word, and I would really like to move forward and do things how it's supposed to be. She's not following the parenting plan in several parts, and this has been an ongoing thing for 3 years now. That's really all I got to say, Your Honor.
All right, thank you. So let me go through these on not letting daycare be a joint decision. It sounds like that's been in place for a while, so I'm going to deny the motion as to that request. As to the concern where Mauricio is living, I think it sounds like he hasn't moved, so I'm not going to find contempt relating to that. In terms of driving past the home, Ms. Gilmore is correct that there's no specifics given, so I'm going to deny on that. As to talking during pickups and drop-offs, the one example was whether Mr. Lopez had some clothing. I think that's an appropriate discussion at a pickup and drop-off. So I'm going to deny the restraining order as to that. That really leaves, I think, the main issue today, which is the pickup and drop-off with third parties. And from the declarations, it sounds like Mauricio gets upset or cries or shows some reaction when he's going to be brought to his grandfather, or I guess the most recent case was with the girlfriend. I think on one level, if you have a child and he or she is crying, it's reasonable to not have the child continue to be upset and in this case, deliver the child to the grandfather or girlfriend. On the other hand, we have a parenting plan that says that these third-party drop-offs are okay. It also is difficult for me to see how Mauricio is not familiar with the grandfather and other people in Mr. Lopez's family. So I'm going to use this motion to provide some direction. So I'm not going to find a contempt formally, but I am going to make it clear what the expectations are going forward. And if these expectations are not met, then I will find a contempt relating to the drop off. The drop off to third parties must occur. I think they should be limited to either the grandfather or the girlfriend. And if Maurizio is upset at the transfer, then he still gets transferred, because I suspect that it won't be more than a couple minutes after the transfer that he'll calm down, that somebody will take him out, get him an ice cream cone, do something that's going to transfer his attention to where he's at. I think it sounds like both parties were overly reacting to a child who just didn't like being exchanged at a particular moment. That can be a stressful situation, but it has to occur. So the direction is that Ms. Friend needs to deliver Maurizio either to the grandfather or the girlfriend at the time of these exchanges, regardless of whether Maurizio is exhibiting that he's upset at the time. And so that's the way I like it to go forward. If that continues to not occur, then Mr. Lopez, I would expect you would bring another motion for contempt, and it is likely that I would grant that at that time. Okay.
Just further direction that these parties shouldn't be making statements and getting out of the vehicle. I mean, that's part of the court order.
That court order should be followed. So if the mother brings the child over to the vehicle and the parties are inside, that's what should happen. Now, it seems you might have to exit the vehicle to put the child in the car seat. So, that would need to happen. But I think the idea is not to have parties meeting each other in the middle of a parking lot, that they need to be in their vehicles. Okay.
So just real quick, Your Honor, sorry. So does that mean basically that, say, if I'm dropping him back off with his mother, that I walk up to the car and I put him in the car, or?
Either you put him in the car, or if she gets out and wants to strap him into the car seat, that would be acceptable.
Yeah, I'd rather that. All righty.
Okay.
Okay, thank you.
All right. Let's
Is
go.
the court the order?
Your Honor, this is Beth Fellows.
Yes.
Starting ad litem. The Vaughn Kiyoshi matter is on
Yes.
today. I believe actually that it's going to need to be set over at least a couple of weeks. The father apparently emailed his domestic violence evaluation to me this morning, but I have not had a time to review it, and it is not filed with the court as well. I did email the father last night, telling him that he needed to sign an ROI for me to be able to talk to the provider, but I got the evaluation, but it needs to be set over for at least a couple of weeks so I can review it. It needs to be filed with the court, and mom needs to get a copy, I believe.
All right. We're also on for child support on that case, I believe. So let me call that Alexandria Vaughn and Mr. Kiyoshi. First of all, let's address what Ms. Fellows just said. She's asking for a 2-week set over to review things like visitation because she just got the evaluation documents. Any objection to that, either of you?
I don't have an objection to it, but I also haven't been served a copy of it either.
Okay. Did you send a copy to Ms. Vaughn?
So I called them alternative counseling yesterday, and she got it into me late afternoon, and that's why it was so late. I did make sure to send a copy to Ms. Fellows. I don't see why we have to hold it over. I mean, I have it here, and Ms. Beth Fellows can look at it later, but I can see the treatment that they want.
Well, Ms. Fellows needs to review it in order to provide some guidance to the court. And so that's okay. She needs to look at it.
Yes, Your Honor.
All right. So we'll put this over 2 weeks. Let me, I don't know if I have it up here. Yep. Just a minute.
It looks like May 31st.
Okay. So we'll put that aspect over to May 31. Ms. Looney, are you prepared to discuss child support?
I am, Your Honor, but I also did get late information regarding Mr. Kiyoshi's income information. I can give the court a verbal recitation, or if you prefer, we can set both matters over those 2 weeks so I can get everything in writing out to everyone.
Well, I haven't seen any proposed orders in the file, and I typically would review those.
Yes, Your Honor, we didn't make proposed orders simply because this review of child support was ordered by Your Honor prior to us getting involved in the case. And we were just going to make an order based on what you ordered in the hearing. But I can get updated worksheets out to everyone.
We need to put everything over to May 30. I want.
The father did provide financial documents and things like that. Apparently they were filed on the 15th. Did you get copies of those, Ms. Looney?
I did. Yes, he did deliver those to us on Monday. So I have reviewed those. That information would change our original proposed worksheets.
Okay.
Okay. All right. Ms. Vaughn, any objection to putting this over?
I have no objection to putting it over, but I know last hearing we had talked about proper service, and you had told him he needs to serve it to my sister across town, and he did not do that again this time. He left all my documents with Beth. So again, I just want to reiterate proper service because it then took me another day to get everything from Beth.
Service needs to be at the sister's house. We went over that. Blacklaw and Myers. All right, we'll see everybody back here on May. Ms. Myers, can you unmute yourself now so we can talk to you? I see your note. There isn't anything that I can do to unmute you. It's indicating that she's willing to reply to anything through the chat. So I think to go forward, we probably need to do that. Ms. Turnbull, I guess we'll begin with you. You've issued your report. And first of all, Mr. Blacklaw, did you have a chance to read the report?
Yes, Your Honor.
All right. And Ms. Myers, did you read Ms. Turnbull's report? Okay, she also read it. Thank you. Ms. Turnbull, maybe I'll turn it over to you to briefly discuss your report.
Well, I think that my recommendations are clear. I have very serious concerns about Hazel's safety if she were to be in mother's care. The abuse that Hazel suffered while she was in mother's care is very concerning. It was extreme, and Hazel is our mom. Ms. Myers is still with the partner who is the likely perpetrator of the abuse against Hazel. She is not acknowledging that, and further crimes were committed subsequent to that abuse against other people. And I think that it's appropriate for Hazel to be in father's care for her safety. And the rest of my outline, my recommendations are in there as follows.
All right, thank you. Mr. Blacklaw, any response?
No, Your Honor.
All right. Ms. Myers, any response? I'm going to read what you wrote into the record so that there is a record of it. You've indicated there has not been any charges placed regarding this, and that was not put in the report, was me being jumped. Okay. All right. Have there been telephone and video visits occurring right now with Hazel?
Yes, Your Honor.
And Mr. Blacklaw, I guess I'm asking you, how have those been going?
They've been interesting. We've been trying to work a good schedule. Monday and Fridays, we typically have them, and sometimes she blows up, sometimes she doesn't, but we've just been carrying on with them. So we've been making them every week, twice a week.
All right.
And you may recall that the prosecuting attorney in Columbia County is still reviewing and asking the investigator, the detective Peabody, for more information. So they are still determining whether they're going to file charges.
Charges against the mother? Or against Mr. Blacklaw?
Both.
Right. Okay.
Not Mr. Blacklaw, Mr. Minyard.
Oh, okay. I'm going to make a couple decisions today after reading this. So the decisions I'm going to make are temporary. They're a temporary order. Eventually, you need to get to court to get a final order in a permanent order regarding the parenting plan. And it's good that Ms. Turnbull has completed her investigation, because that will be helpful to the court when it gets there. So I want to give some direction on that. I'm going to accept Ms. Turnbull's recommendations in that Mr. Blacklaw will have custody of Hazel Blacklaw, and he'll have full authority to make medical and educational decisions. I am also going to adopt the recommendations that Dakota Myers, one, engage in domestic violence counseling, two, participate in a collateralized mental health evaluation with a parental risk assessment by a PhD level evaluator, three, submit to hair follicle analysis, and four, when she's completed that, then her potential visitation with Hazel can be revisited. The guardian ad litem has suggested that I reconsider the video and telephone visits. I'm going to leave those in place. I don't see where those are creating a safety issue. And I do not want the child to be completely out of contact with her mother. The rest of the recommendations, I believe, are going to need to be addressed at a hearing in front of a judge regarding the final plan. I'm going to put this on the universal trial setting calendar. On that date, you will be able to set, I'm going to set it for a one-day trial. You will be able to be assigned a judge to obtain a final parenting plan. For the purposes of that, I'm going to waive the requirement that you go to a mandatory settlement conference or a mediation. I don't know that that's going to be successful or helpful in this case. I think this case needs to go directly to a trial. So I'm going to enter an order indicating that. And then I'm not going to set another review in this case. If either party feels there needs to be a review in front of me, you can ask for that, and you do something called noting up the hearing. But at this point, your next hearing will be May 31 at 1 o'clock, at which time you'll get a trial date. Okay. Mr. Blacklaw, any questions?
No, that pretty much covers it for today.
Right. Ms. Myers, any questions from you?
I do have one. Is it okay if I file her on my taxes now?
I think that should be appropriate. She did write a couple of other things that I want to read into the record, so we know what they are. She writes, "Why am I taking domestic violence classes? I have not abused anyone. How is this fair at all? I like how none even asked any of my references." So part of the domestic violence counseling, and I'll just read what Ms. Turnbull wrote. She's asking that you engage in domestic violence counseling to heal herself and identify the signs of an abuser. The concern, I think, is that Ms. Myers continues to live with Jeremiah, who is the alleged abuser in this case. And so Ms. Turnbull is asking for that as much for Ms. Myers' benefit as anyone else. Okay. All right. Then your next day in court. Kyle Weiss and Chris Shumate, are you with us?
Yes.
Ms. Shumate's here.
I'm here, Your Honor.
All right. Kyle Weiss is up there. The two issues that I think are on for today, and everybody can correct me if I'm wrong, was Ms. Shumate was to provide medical information to Mr. Weiss, and then we were going to once again review the social media account. I did see a subsequent declaration, and I have some questions about. I did see there were motions for reconsideration filed. we are required to hold those for 10 days, or at least my staff does. And so those don't formally get to me until May 20th, which is 10 days after they were filed. So I did see them in the court file, but I haven't been given those. They haven't been given to me formally at this point. Mr. Weiss, let's start with the medical information. Did you receive that?
I haven't received anything as of today, Your Honor.
All right.
Disregard. I did ask for Taylor's medical card. She did provide me with that. However, any other documents I have not been provided with.
So you don't have a list of where Taylor has been treating over the last, say, year or 2 years?
I do not. And I want to speak for the record. The medical card that I was provided for Taylor is an invalid insurance plan. It is through state healthcare. Taylor is not a resident in the state of Washington. Therefore, she does not qualify for state healthcare. I wanted to just state that for the record. And everything else, no, I've not been provided.
Okay. And while I'm talking to you, you provided a page of screenshots from, I assume it was TikTok. And when were those screenshots taken?
Just a couple days ago.
Okay. All right. Ms. Fellows, anything you want to add at this point?
No, Your Honor, I don't have anything, any additional information.
All right. Ms. Shoemate, 2 weeks ago, I believe I asked that you provide the medical treatment information to Mr. Weiss, and it sounds like that has not occurred. Can you address that?
I'm still working on that. I just trying to remember. I know one of her doctor's offices. I'm here that she's been to for a while, but the one in Rochester, I can't remember the name of the clinic. I'm trying to look through my paperwork that I had for her because I keep all documents from doctors, but I have that in storage, so I'm trying to find them.
Did you understand that if that was not provided by today, I was likely to find you in contempt?
I do understand that.
Okay.
And to the TikTok, I just found the that TikTok account that he's talking to. I am in the process of trying to delete that one. I'm trying to remember how I did her other one because it's been since 2020 since she's had that one. So I'm trying to figure out how to get into it.
Your Honor, my response to that is that was the same response when we first brought this to court, is she was trying to figure out how to delete it. We've held this one over 3 to 4 times, a couple months now. I think that's been plenty of time.
Your Honor, well, I didn't see this one until I got his declaration on which one, and I just found it, and I am trying to get into it.
Okay.
Because to be honest, I did forget about this one. She did have a different TikTok, which I trying to figure out how I deleted that one. But I did get a hold of, I sent a message to TikTok saying it's court ordered to be taken down, but I'm hoping it will be taken down.
All right. As to the contempt that was brought on the medical information, I'm going to find that there is contempt. I think I still have the order that was provided, and I'll sign that. I'm going to put this over 2 weeks to the 31st. At that time, the medical information will need to be provided or the sanction will increase. I'll find another contempt at that time. So I'm finding one today, and I may find one 2 weeks from now if the medical information has not been delivered. As to the TikTok account, I'm going to enter a separate court order indicating that that account needs to be taken down. And the purpose of that is if Mr. Weiss wants to take that order and take steps himself to get that account taken down, he can do that. Additionally, the order will say that the daughter cannot maintain any TikTok accounts until she's 18. I think I made it clear that if the concerning material on TikTok was not taken down, that I would prohibit the daughter from having a TikTok account going forward. So that's what I'm doing today. All right. We'll see everybody back here then on May 31.
I have a question.
Me too. She can go first though.
All right, go ahead, Ms. Jimmy.
For the medical, am I just sending him the name of the clinic, or what exactly am I sending him?
I think what we're asking is the name of the clinic where she's treated and what her current insurance status is.
Okay.
Your Honor, I think that there needs to be like potentially releases of information signed by the mother, because I think the father has in some instances been restricted from accessing any information. So in order to make this a smoother process, it makes more sense that not only, name, address, phone number, contact information, but also an ROI must be signed by mom to allow dad to talk to the provider and gain those records.
Okay. I will agree to that. So on each of the medical providers where your daughter is treated, then Ms. Shime, you'll need to get a hold of them and sign whatever documents they have to allow Mr. Weiss to discuss your daughter's treatment or care with them. And that's typically called a release of information or an ROI, as Ms. Fellows has indicated.
Okay.
All right. That needs to be done in the next 2 weeks also. Okay.
Okay.
And then I'll
Mr.
finish.
Weiss, question?
Yeah. I know you said you can't do the motion of considerations right now. Will those also be on the 31st?
No, those are usually handled without oral argument. I'll just base it on the pleadings that you submitted.
Copy. How will I find out the results of those?
I will write a decision and that will be sent to everybody.
Sounds good. Thank you.
Okay.
Thank you, Your Honor. So we'll
and
see
Melanie
you on the
Viola.
31st.
On the 31st.
Yes,
Your Honor, Donald's here.
Okay, good. I'm glad everybody's here. Last time we were together, I requested both parents do a hair follicle, 12-panel hair follicle test and do a mental health evaluation. That was at the request of Ms. Height. Has that been done at this point, or is that in process? Ms. Vianola, do you want to respond first?
Sure. I spoke with Anne and I called the places just to check the two that were recommended, and they don't do court ordered follicles, but I have psoriasis of the head, and she was okay with, I have been seeing Metrics Clinic for the last 3 years, and I have not had one dirty UA in about 3.5 years. She said she was okay with me releasing that as a means of providing a UA, and then so I have been seeing a psychiatrist and already have had mental evaluations, which I released that to her, or released that information to her too. So she was okay with that. I hope that's still okay, but that is what I've done.
Mr. Jervy, have you been able to take care of those requirements?
Yes, Your Honor. I went to the Core Health here in Longview and also the Occupational Health for the hair follicle, which is in Longview too.
Okay. Ms. Height, do you want to address those requirements?
I would like to, Your Honor, because my evaluation of it is a little bit different than what you've heard here this morning. I did talk with both parties about it. As you recall, when we were in court last time, my concern was that those would be taken care of, and your order was that they would be taken care of by end of business the following day. That was not done. Part of my major concern on this is the alcohol use of the parties, and that needs to be done immediately after your order. It was not done by either party. And in fact, that is Driston's main concern with me, is that when alcohol is consumed, which sounds like it is somewhat regular, it affects his relationship with the family. And he has, in the interim between our last visit and now, re-stressed that with me. So I did speak with both parties, and Ms. Vianola is correct. She shared that information with me. I was not okay. I agreed that was the information we got, but I did not agree that it was adequate. For one thing, and I understand that she has scalp issue. However, we call this a hair follicle test. It is really not hair that's taken out of the head, is usually an inch to an inch and a half that is cut. So there's no real impairment of the scalp. It could have been done. She chose not to do that for her own reasons, and I think that's information for the court to evaluate. Again, my concern for both of these parties, as much as the hair issue, was the unannounced observed UAs, and those have not been received. In addition, the records that have been referred to, I have not received anything from either party. I take that back. I did receive yesterday, I received the follicle or the hair report from Mr. Derby, which came back with marijuana use on it, but nothing else. As far as I know, he didn't do anything with the alcohol. Although when I spoke with the provider of the follicle, I said, there's really no point if they haven't been in there by the end of business on the day that you prescribed, which they had not. I didn't see any point in that at that time of doing a UA, because it does not provide that immediate information that was so critically important to me. And my frustration is that you asked for 3 things and nobody really did all of them. The other thing that I think is of interest is that the other thing you asked for was that Driston engage in some phone conversations with his mom. And I've talked with him since our last visit 3, maybe 4 times. I visited him at home, and I've talked with him on the phone several times. And he has made some of those calls. He admits he didn't make every one of them, and that they've gone okay. He was quite specific with me when I spoke with him yesterday, that he wanted to keep the phone call visitation as is. He does not want to move forward with other visitation. He and I talked at some length about various options, and we made a kind of a temporary preliminary list of things that would help him feel comfortable having in-person visitation. And in fact, he did have an in-person visitation with his grandparents over one of the weekends here recently, which he said had gone well. But at this time, he wants to leave things as they are, as the other parties have basically not done the most key piece of information that I wanted. I'm inclined to follow Driston's request and leave things as they are until we can get some unannounced observed UAs. As I stated before, that has been his major issue regarding why things do not go well at home.
That is mother's.
I would also like to say, Your Honor, that in my conversations with both parties, they have been cooperative. They've been forthcoming. I think that there is some information that has not been given to me or hasn't been given to me correctly, and that's going to require some more digging. But I personally have found them to be cooperative at this point. I think I'm not hearing the whole story and the true story every time, but nevertheless, I think we can move forward and get the information that the court's going to need for Driston.
All right, Mr. Derby, why don't I hear from you first? Any response?
Yes, Your Honor. I went to the Core Health and did my medical evaluation that following week, and then the next was the hair follicle, and it was $125, and I had to wait a few days to take that, so I took it right away as soon as I could. I don't know if there was, I given all the ROIs to Anne, so I don't see where I didn't follow anything, and I was under the understanding that as long as we did it before May 17th and had the information, then we would be okay. So I didn't know why I was being in that type of like I was being put in that category.
And you know when the mental health evaluation will be completed from Core?
I've already completed it, Your Honor.
I know you've done it, but they have to do a report, I think. Have they indicated when that would be ready?
The doctor said that the ROI was released and that Anne could receive the information whenever she wanted. So
Okay.
and that's all. And then I just left the facility. I just was under the understanding that Anne was going to go get the information. I gave her the doctor's name and the phone number, but I didn't think I needed to do anything else.
Okay. All right. Thank you. Ms. Vianola, any response to what Ms. Height said?
Well, I mean, I completely disagree with this isolation that has gone on for now. We're talking 6 months, 7 months. I haven't seen Tristan, and only one time has he initiated a phone call, and his dad is always in the background. And I can hear dad talking. And the first time we talked, he was telling me all about his week because I'm to a guideline of a few things that we can discuss. So I can't talk about futuristic things because I don't know what the future holds. But he was excited to tell me about ceramics, all this stuff. And then the next week I had to call at, I believe it was 7 o'clock I had to call, or 6:30. Our time, I think, is 7. I'm not sure. Can't remember exactly, but in between those times. And he sounded like he was not interested in talking to me whatsoever. And 100%, I believe that my son has been given complete control now to the person who has been parent alienating him from me for the last 2 years. I mean, and it's unfair that, you know, okay, I misunderstood that and took that as acceptable. I did understand within 24 hours I needed to do something. I did contact Core Health and Columbia Wellness. Both of them said they do not do court-ordered hair follicle tests. So I did look around. There is one place in town, it's Peace Health or something, and it's $300 and some. And financially, after paying as much as I have in the courts and everything, we just don't have the money at 24 hours like that. I mean, we just don't. After lawyers and everything, I can't at the drop of a hat do that. I could do a blood test at my, through insurance. I could UA through my insurance in 24 hours, but that kind of money out of pocket, just I can't afford anymore.
Did you go to Core Health for the mental health evaluation?
I have gone through Family Health Center, and I didn't know that by just releasing the ROIs, I should have that printed up or something printed up and sent to Anne. So I did release all of my stuff after she did the home visit. I see Carla at Family Health Center. So to me, I didn't see why I should have to redo a mental evaluation when I have been seeing somebody currently and in their care. They do mental evaluations, but you don't get in right away with Core Health, even if it's court ordered. I called and I asked. So that I do know for a fact. So I don't know how that would have been either possible for either one of us to do within 24 hours, since neither one of those places do it. Also, Mr. Derby texted me on May 9th. And this is pertaining more to the no contact order with my son that has no backing or reasoning for, but he contacted me 19 times. He told me he went to OSHU. I already got his hair follicle test. It cost him $500. And he was telling me what I needed to tell my mental evaluator. And that started at 5 o'clock and it ended at 8 o'clock at night. This is what he does. And I'm not allowed to even call my son, but he can contact me nonstop. And I've never been able to get a no contact order or anti-harassment order against him. Never. They never granted me one. So that's really my thing, is that my son was taken out of my life in contempt of court, where he had no, he didn't get in trouble for any of that. He got rewarded by me losing all rights to my son and only getting a phone conversation that doesn't even happen, and it's not in privacy. So Tristan is not going to be able to openly talk to me. And he went to my parents' house because Mr. Derby knew we had court. And that's what he does every time we're in court, is he sets things up. I know this sounds like I'm attacking, but we've done this for 13 years. It's a history. It's a pattern. He sets it up. He starts doing what he's supposed to look good. And then the second the court's not involved, he does not care about the parenting plan. He does not care about any rules or the court judgments. And he does whatever he wants. And somehow I have followed the best I can, except one thing. And I've lost all my rights for nothing.
We talked to Ms. Height again. She indicated she would do an ROI of her, I guess, counseling records. Is that sufficient, or do you still want her to do a mental health evaluation, either at Core or Columbia Wellness?
It would probably be helpful, Your Honor, to see how recently those were done. And I'm certainly willing to consider that. I don't have to have it my way exactly. But I've not received any information of who to contact, how to contact. I did get, as Mr. Derby indicated, I did get a phone number, but I have not received any subsequent information on his evaluation. And it may not be ready to be dispersed yet. I don't know. It was done. I've got the date here. I believe it was done fairly recently, so I'm not surprised that I haven't received it. I would like to beg your patience to discuss the phone calls just briefly again.
Okay, go ahead.
When we talked before, our intention was that Driston would initiate these phone calls and that he would have a way of showing that he was engaged in doing this. And I still think that's a good idea. And having spoken several times to him, I think that he's capable of doing that. When he did not do them in a timely way, Mom understandably initiated the calls. And I think it would be worthwhile to see how he can do without anybody else initiating the calls. And so I would request that we tighten up some of the language on this and ask that my request would be that we continue with the weekly phone calls and that Driston be required to initiate those phone calls and that Driston be required to do it in a place and a time in which there is not oversight by Dad or anyone else. If that just means going outside and doing them at some other time, I mean, he should be able to figure that out. We had him on a certain time for a good reason to do it Thursday at 7 o'clock. That seemed like it was going to work for everybody. There may need to be more flexibility in the time frame of doing them. But what I want to see is Driston taking the initiative, Driston doing that and feeling like he has some agency here, that he can make some headway in having some say so. And so I feel like that's one thing we can keep trying to do. Meanwhile, as I said before, there's some shortfall in what's happened on both of the parents' part. And I think basically they've chosen to misunderstand or chosen to forget when it's convenient, to be very frank with you. So I would still like to see Driston initiate those calls, and I'm certainly willing to contact him again. And I feel like he and I have had good conversations. And he's been forthcoming with me that he hasn't done them all. But he said when I talked with him yesterday, he said he was going to get on board and do those. So I know it's hard to be separated from him, and it's going to be a process to get him reintegrated, but he's very agitated right now about visitation. So I would like to see him allowed to initiate those calls and see how they go.
Okay. Thank you, everyone, for your input. Let me just remind everyone that you have a trial set the week of July 3rd, and there'll be a readiness hearing before that. So that's coming up. I'm going to order that both parents complete a UA by tomorrow at 5 p.m. And if that wasn't exactly clear last time, I want it to be clear today. If it's not done by 5 p.m., then that's a factor that's going to enter into the court's decision-making when it comes to addressing custody and visitation. Secondly, I'm going to take Ms. Height's recommendation. I'm going to order Driston to initiate the phone call to Ms. Vianola. I'm going to leave that every Thursday at 7 p.m. Mr. Derby cannot be within hearing distance of that phone call. And that phone call will last as long as Driston wants it to last. Okay. And I think I need to set a review here fairly shortly. So I'm going to do that on May 31. I want to confirm that at least 2 phone calls were initiated by Driston and that they were productive. And I want to confirm that the UAs were done by May 18th at 5 p.m. If those things are not happening, then I'm going to be seriously concerned. Okay.
Can I ask one thing, Your Honor?
Sure.
Anyway, since a phone call is essentially the same as a video phone call, is there any way we could do that? So that way I get the security of knowing he's outside or nobody's around him. I know that because I know his dad's not going to allow it and I can't prove it. I mean, how do I prove something that I know in my heart, because I know the meat of our life, that he is not going to allow him to have private conversations with me. So maybe at the times, maybe I'm on a lunch break or somewhere where he's not in Dad's possession, I guess I could say.
Well,
I know that's difficult, but
the problem with making it whenever it's convenient or whenever Dad's not around is my experience is that then it's not going to happen. And if we have a specific time and specific date, then it's more likely to occur. Secondly, I'm not going to assume Mr. Derby is going to violate a court order at this point. If he does, then that's going to create some other concerns. And I'm going to let Tristan decide if he wants them to be, on FaceTime or some other video setting. You certainly can talk to him about that. But I'm gonna let Tristan have the decision on how he wants that to occur.
Your Honor.
Yes.
Your Honor, as you allowed last time, can I notify Tristan about this? And I know we don't like to talk about court action with kids, and I try to be super careful about that. But I would like to be able to tell him that this is court ordered by Your Honor, and it was done today, and that he is to be separated from his dad during these conversations. I believe he can be responsible to do that, and I think it would be good for him to exercise his responsibility to make sure that that's happening. But I guess I would like authorization from you to be able to give him those details from today's court hearing.
I think that should come from you rather than anyone else. So yes, I think you should inform him about that.
Okay.
And then we'll be back here in 2 weeks and see how that went. Okay.
All right.
Thank you.
All right. All right. I saw the domestic violence evaluation indicated it was low risk, but that also indicated 6 months of treatment. Has anything been done to get that going?
Yes, Your Honor. I have an appointment this afternoon with the counseling interventions for an intake.
Okay, good. Good. Right. I think you were in front of Judge Fassett until recently. And so I probably need a little bit of history as to what was going on with Judge Fassett and what led up to today. Why don't I go to, I guess, Ms. Jones, is that?
Yes, sir.
Your name now. Okay. Good morning.
Good morning. We actually were in front of Judge Fassett only once.
Okay.
And since that time, I have become pro se. So that's
okay.
The switch.
Who was I the judge before that or the commissioner before that? Or who did you see?
No, we were in front of Judge Scudder.
Okay. And then the judges rotate every 2 years. So there was a rotation and then Judge Fassett came in. And then when you became pro se, it went onto my docket.
That's
so right now, I'm not sure too much of the history. I'm interested mainly in what kind of custody and visitation arrangement everybody has with the children at this point.
So right now, there is no visitation or anything other than reunification counseling. And that's been really difficult. And so I don't know if I need to bring a separate motion about that to actually talk at length about reunification counseling, but that was my plan.
So that's been, from your perspective, difficult for your children?
That's correct. And I think today was just about making sure that Mr. Lakey had filed his domestic violence evaluation. And then I had asked him if he planned to engage in treatment. And today is the first news of that for me.
Okay.
Yes, it has been rough, Your Honor. It's an ongoing thing, and Mrs. Brandhorst wants to keep the reunification counseling going, even though I'm doing the domestic counseling at least maybe twice a month, at least every other week, so that there's nothing lost in we've gone through so far.
Okay. How long has that been going on?
It's been since I met with her twice in December, and then she met with Mrs. Jones and I, and then we started meeting with daughter Rosie. And that's been since January. And then there was a few times where appointments were missed because of COVID and myself being sick.
So Your Honor, there have been 10 visits since reunification counseling has started. Our son is not choosing to reunify at this point. He's 17. The reunification counselor had okayed him to be done with the process. There was only one visit in April, and we were doing weekly visits. done one visit in April and now every other week. So it's kind of tapered off quite a bit and just really upsetting to our daughter to have to continue on with the process.
Okay. Well, it sounds like today was to confirm that the evaluation was done and that treatment is started. It looks like it has been. Whether it sounds like you're going to hear from. All right, Chavez and Chavez. Either of them here.
I'm here.
I'm here, Your Honor.
Okay. Good morning to both of you. Mr. Chavez, I think this is your motion for contempt. Do you want to address it?
Yes, Your Honor. According to the Exhibit A in the parenting plan that you set up with the recommendations of our guardian ad litem, Tina, stating not to have that we can't have a significant other live with us within 6 months before introducing that person into Austin. And Ms. Chavez has had this guy, Jason, living with her for a couple of months. And that's what I've been finding out is that, you know, that's against the parenting plan that the court has set up. You know, and it's like I've been following with what the court has been telling me to do, this and that. We had court yesterday because she renewed a restraining order on me, which is like, I think it's low because she knows I had no contact in like over a year with my stepdaughter, her daughter, Jasmine. I tried to have a couple of conversations with Kyrene when she came over and pick up my son and stuff. But, you know, it's like little petty stuff that she's been doing. You know, she's still questioning my dad on what am I doing? How come I'm not home? This and that. And then last time I heard that's harassment, but my dad won't turn her in or say anything about it because she does drop our son off over at my parents' house so he could see him. And my dad's afraid that if he says anything, then she's just not going to be bringing Austin over only on my visitations. And right now I've been trying to get a new parenting plan set up so, you know, I can have my son on the holidays this year, because last year Ms. Chavez kept my son away from me and my family on all the holidays, but let him come over for a couple of hours on Christmas, which, you know, we were all happy about that, you know, but it just seems like, you know, since the start of all this with the parenting plan and with guardian ad litem getting involved and the parenting plan with the Exhibit A set up, Ms. Chavez hasn't been following the parenting plan, even though I have been though, but it just seems like, you know, I'm always getting like, it's always like, it feels like I'm always getting punished for all this, even though I haven't done nothing. You know, she's telling my dad that, you know, she's hoping that, you know, I don't get my son doesn't need me, this and that. And I can't set up a new parenting plan because of this one's going on and that I couldn't take it to trial or nothing like that.
All right, thank you. Okay. Ms. Chavez, any response?
Yes. This was a person I was friends with and I was trying to help out and it turned bad. The said person called CPS and said I was hurting my child. CPS got involved, talked to my kids, talked to me, and there was no proof of it at all. And Mr. Chavez knows I would never lay a hand on my kids. So the person that he's talking about was just in a psych ward that I had to put him in. So I don't think we could believe him. That's just my perspective of where he was at. But we do have a court order, protection order, because my daughter wanted it. So I renewed it. And he has broke it because he has texted me that had nothing to do with her son. In the court order, the new one, he is only allowed to talk to me about her son. And he's never texted me because you have said it's okay for him to text about child. He's never asked. His stepdad calls every night to check on our son.
You blocked me, Kyrene.
Mr. Chavez, it's Ms. Chavez's turn. So.
And if somehow I'm going to be like, because we have a set time we normally choose as 7 o'clock. Well, there's some days I get off at 6 and it takes time to go grab both my kids if they're not home. And then I come home. And if I'm going to be late, I will text him and be like, hey, I'm going to be late. Have him give you a call, or he changes his time to 8 o'clock. But he always talks
to her son. That's a routine. That's been a routine for a long time.
Ms. Chavez, we're getting a little bit away from kind of the central issue. On January 12th of this year, I entered a bench order adopting the suggestions and the recommendations of Ms. Day.
Yes.
And one of those was both parents should refrain from introducing any new romantic interest to Austin until the relationship has remained committed for a minimum of 6 months. Introduction should occur with Austin's best interest in mind, and a background check may be beneficial. Mr. Chavez has indicated that you've moved a person named Jason into your house, and that would violate the 6-month requirement. So I think that's what I want to address today.
I did not move him into my house. He stayed with me a couple days, and I took him back to his father's house. And we weren't together. It did get intimate at a couple points, but we were not together as a couple.
Your Honor, they walked out naked.
Just a minute. I want to make sure she's finished.
Okay.
And I'll give you a chance. Anything further, Ms. Chavez?
Not to this part.
Not to that issue.
No.
What contact did Jason have with Austin?
He was around him, but he was never with him without me. But it was just friends, and it kind of just a little intimacy, but there was no farther than that. And then he was having mental issues, and I admitted him, and I told him he couldn't be, we were done. I couldn't help him anymore. I'm a person that likes to help people, but he crossed the line. So he wanted to ruin my life more because I told him I couldn't associate with somebody like that.
All right. Mr. Chavez, any response?
Yes, Your Honor. CPS did call me last week because somebody did an anonymous call on my wife. And I told that lady that I've never seen my wife hit either of the kids, you know, with a closed fist. You know, open hand is okay. That's what the CPS worker said. And I told the CPS worker, I can't remember the last time, you know, either me or my wife has even spanked our kids even when we were living together. But not only that though, you know, I meant like, you know, I just want to make sure my son is safe. And then I found out too from my stepdad that apparently this guy, Jason, not only hit Kyrene, but hit my son. And I asked my dad, if this supposedly happened, why didn't she call the cops on him right then and there instead of wait a couple of days to even go get a no contact order on this guy? You know, I just don't understand why she just didn't get the law involved right then and there, supposedly when it happened. You know, and I said, you know, I've been following the Exhibit A form to the T ever since we started this all. You know, this is the second time she's had a guy around my son. And, you know, and I'm just worried about my son. I'm trying to get I'm trying to get my son, you know, with me just to make sure my son is safe because of all these guys she's hanging out with. You know, this Jason guy has mental issues. You know, what's next? Is she going to have like somebody who was a convicted murderer, you know, or even worse? You know, I've been trying to get my emergency custody, but I have her telling my parents, you know, I had people telling me, well, you know, this is all going on, this and that, you know, that it's not going to be a good chance. And on my side of the court that I'm going to get any more days with my son, this and that. And like after this, I have to go and I have to hold her in contempt of court yet again. Because I'm finding out like this law or whatever called the refusal law. And I Googled it a couple of days ago and I forgot to screenshot it because I was trying to understand it more. But it states that, you know, if my wife, you know, doesn't have a babysitter, this or that, you know, I'm supposed to be first pick. She's supposed to let me know like, hey, I need a babysitter, you know, and I didn't know if that was still part in the law or what. But if it is, you know, I just want to know like anytime she needs a babysitter. And my dad's even told her, you know, Austin could come over to see me. You know, and she's been trying to get me set up with having Austin come over to my parents' house because she still believes that when Austin is over there on the times of my, like, because I have him Wednesday and then every other Friday, Saturday, Sunday. So if he's over there on a Tuesday or a Thursday.
Mr. Chavez, I think I'm ready to make a decision. Okay.
All right.
All right. So the parties were before Judge Evans earlier this year on a motion for contempt because of contact with Mr. Sergeyev. And at that time, the motion was denied. But it had to be clear at that time to Ms. Chavez that the order that I entered in January, was what was at issue in that motion. And there really is no, it really is not ambiguous in terms of what it says. But now we're back because of information, and it's confirmed that somebody named Jason moved into the house. Ms. Chavez says she likes to help people. Jason comes in, he stayed there until, and I think her words, if I remember, were he went too far. Whatever the words were, it suggested that there ended up being some sort of concern about Jason. And if there's a concern about Jason, that's a legitimate interest for Mr. Chavez. And I guess Jason has left at this point, but I think the concern by Mr. Chavez is well taken. This time I am going to find contempt for violation of this provision. And I'm going to make sure that this is understood and that this happens before any male moves in with Ms. Chavez. She needs to disclose the name to Mr. Chavez and let him know that so-and-so is moving in with her. I don't care if it's for one night, a week, or for months, because whoever moves in is going to have contact with your son, and Mr. Chavez has a legitimate interest in making sure that his son is safe. So I am going to find contempt relating to Jason. I'll sign an order to that effect. And I'm going to make it clear that that disclosure has to be made. Mr. Chavez, briefly.
Yes, I did submit evidence that, there was proof of him saying, that he was living there, and she even admitted it to my dad. I just didn't know if you have the.
Sure, I just agreed with you on that. And I found contempt based on your motion. You don't have to argue it again.
I'm not trying to. It's just really static in this booth. So.
All right. Well, hopefully going forward, you're going to find out the name of whoever is going to move in. And if you have any concerns, you can raise those. Okay.
Your Honor.
Yes, Ms. Chavez.
Mr. Chavez said that he assaulted me. He did not. And I did hear from the social worker saying our son said that, but I didn't see it, that him hurting him. And if so, I would have thought my son would have told me. And if it was, I would have let him know. And if somehow I couldn't have got a hold of him, I would have told his stepdad, and then I would have went that way. But that was the first time of hearing it from the CPS worker, and I was shocked.
I haven't made any finding regarding that today.
Oh.
Okay.
Okay.
All right. Thank you both. And I hope everything goes well going forward.
Okay.
Is there going to be another court date after this, or like what's going to happen?
Well, if I think the recommendations of the guardian ad litem need to be followed, and if there's any concern about that, in the other orders I've entered, if there's any concern about that, you can bring it to the court. And if my orders are temporary, it may be the right time, I guess, for you to start moving this towards a permanent order. And what the first thing you would need to do is ask the court for what's called a mandatory settlement conference. And you would set that up through, you would put it on. So, Mr. Lawrence, did you have a chance to talk to Parker in the last week?
Yes, I did, Your Honor. I met with him at school on Friday of last week, and I was asking him about how the telephone calls with his father were going, and he indicated that they were doing fine. And I asked him if he was ready to go to the next level of contact with his father by having face-to-face visits. And he said that he was not. And I asked him why, and he indicated that he had heard stories from his mother and his brother about his dad's verbal aggressive behavior. And he was concerned that that might happen when he went over to visit with his dad. And so I asked him about reconciliation counseling. Initially, when I met with Parker at his home, he indicated he was not interested in reconciliation counseling. And I assumed that that was because him and his dad had a good enough relationship that he felt they could patch things up without needing to have a counselor get involved. But on Friday, when I met with him, he explained what reconciliation counseling was, that you have a counselor who meets with you individually as well as your father. And then eventually the two of you can meet together in front of the counselor, iron out any issues between the two of you. And then the counselor can start making recommendations for increasing the visits if that's what's warranted. And he felt a lot more comfortable about that. And if I interpreted my conversation with his mother, Kirby, correctly, I spoke to her after I had met with Parker and explained to her what had happened. She indicated that Parker came home and the two of them discussed my interview with him, and he seemed to be pleased with how that interview went. And my interpretation of that was that he felt that he was being heard, that he needed to have some measure of protection, which the counselor would provide, but at the same time, he can try to rebuild his relationship with his father. And so I emailed Mr. Utter as well as spoke directly to Kirby and explained that I would be requesting that the court order reconciliation counseling in this matter, and that we basically leave the status quo of the telephone calls in place while initiating the reconciliation counseling, and then allow the counselor and Mr. Utter and Parker decide when and if they are to take it to the next level. And that would give me, if I could have another 30 days, Your Honor, that would give me a chance to observe this and see where this is moving, so I can have a more complete recommendation for my report.
You have a recommendation of where that could occur?
Well, I contacted Allison Long, who I know is with the Charlotte Rosen group, and I haven't heard back from her. I know that she's busy and all of that, but Charlotte Rosen, Mary Patterson, Allison Long, that whole group is kind of the gold standard in Cowlitz County for this type of counseling, and I would hope that they could get in there. Ms. Young did want to know whether or not it should be in Cowlitz County or in Clark County. I'm not aware of anybody in Clark County. Ms. Young did indicate that she had a preference that it stay in Cowlitz because it was closer.
Let me hear from Ms. Young next. Any comment on what Mr. Lawrence has said?
No.
All right, thank you. Mr. Utter, any comment?
Yeah, I do have a couple here.
Please.
One, the county doesn't seem to matter. I mean, as long as the insurance, last time we were here, we talked about insurance for Parker, and you were going to have the clerk look into his insurance, because we have contacted the place that Mr. Lawrence has suggested here, and they said my insurance was covered there. But if Parker was on state insurance, it wasn't covered there. And if that's something else that would have to be out of my pocket, I was hoping to put Parker onto my insurance, seeing as I've already dropped $3,000 into this out of pocket. Also, I've had contact with Miss Young. We talked yesterday, and together we have talked about, we talked about where this fear comes from with Parker. Parker has never seen me angry, never seen me raise my voice. Other than one time when there was an incident with his brother and the police were called, but it was not directed to Parker. And Parker had came over several times after that incident and was not scared or anything. I believe that was January was the last time he came. I'm sorry. There's never been a fear of Parker's that I'm aware of until now, until January. This is new to me that he is scared and timid. The only way he would know anything is if he was being told stories about incidents that may or may not have happened, really one-sided version of that. I sent Mr. Lawrence an email with pictures showing him jumping into my arms, showing him with us with no fear whatsoever. So this is all new, a new thing. With that being said, of course, the reunification, counseling, anything the courts order, we will go through as we have to in order to get to where we want to be. With that said, Kirby and I are discussing yesterday. She suggested I come to his horse riding lessons. Perhaps we meet at my parents' house. Perhaps we meet at a park. Something for us. I don't feel that Parker is as terrified as Mr. Lawrence is stating, or that Kirby is stating, because of the reasons that she's willing to take it out of the courts and handle it on her own, if that's a possibility. So I don't know if we have conflicting stories. I don't know if there's games being played. Your Honor, I just want to see my son and go from there. It seems like when he was here, we were building that foundation. This time last year, we had a great foundation and it was growing stronger and stronger. Our bond was. And
let me go back to Ms. Young. Mr. Utter has indicated that you would be open to having him see Parker in public settings. Is that right?
Well, one thing I want to say, and this is not trying to be rude to Mr. Utter at all. This relationship that, yes, I believe him and Parker had somewhat of a relationship prior to January, but there was never like any one-on-one time. And that was what brought us here, was like trying to do what was right by Parker, in the sense of taking it slow. And I've told Mr. Utter this and Mr. Lawrence, like, this is all new for Parker. They've never, him and or his father have never went and, had ice cream alone together. It's always been at Mr. Utter's family's, or Parker going to see his friends that live by Mr. Utter. And I want Parker to have a relationship. Yes, I want the relationship to feel comfortable to Parker, and don't want to be, if Parker is scared, I don't sit and fill Parker's head with anything that I may know that has happened or whatever. I want Parker to be safe and feel comfortable. And I believe we both have great intentions for Parker. If it's the counseling that's needed, I'm for that. If Mr. Utter thinks that we can, carry this on ourselves and he be respectful, I'm good with that too. But it is about Parker. And when I had told Mr. Utter that, hey, you got to kind of slow down, he's feeling overwhelmed, that's when it went, that's why we're here, is because of that. And I don't know.
Mr. Lawrence, what if we took some time, let Mr. Utter attend some of these events that are public, lots of people around, and see where we're at on reunification counseling after those things? What would be your thought on that?
I believe that'd be a good idea, Your Honor. I think what has to be primary between Mr. Utter and Ms. Young is that Parker is a very sensitive kid, and he takes his lead from the people that he's around. If he can see his parents trying to work together for his benefit, I think that's going to go a long ways towards making him feel secure. And in a public setting like that, where Ms. Young may even be available to kind of be in the distance, so he can have sight of her, so he knows that she's around, or that this is a public place where there's nothing that can happen to him at that point. I think that's all good stuff. And but he's a kid that is very sensitive. It's going to take a little bit of time for him to feel comfortable. But the key to this whole thing is going to be between Mr. Utter and Ms. Young cooperating in trying to make him feel comfortable.
All right. I've heard today, and I've also heard in the past, really a good level of cooperation between Ms. Drutter and Ms. Young. And so I want to acknowledge that and appreciate it. Reunification counseling can cost a bit. And I think there might be a couple steps we can do here before we determine if that's necessary. So what I'd like to do is put this over a month. The telephone calls as they've been ordered need to continue. And then Ms. Young, I'm going to kind of put you in charge of this. If there are 2 to 3 public events that Mr. Utter could be invited to in the next month, and I'm not limiting it to that, but I would like to see at least that many if we can. I would appreciate if you could invite him over, if it's just simply him sitting in the stands cheering Parker on, or if they actually have contact, whatever, I think Parker is probably going to control some of that, but I would like to see how that goes before we make a final decision on reunification counseling.
Okay.
And Mr. Utter, I understand I'm putting Ms. Young somewhat in charge of that, but I think that is the appropriate thing to do at this point.
I understand, Your Honor. I do have one question, if you will.
Sure.
Now Parker isn't involved in sports that I'm aware of. We've been trying to get him into sports and stuff. My other kids are very into sports, and he's been invited to those. There was a time when he was coming to every football game and stuff like that. With that being said, my daughter is in districts for softball. Will there be a time maybe he can be invited, or she can come to those? Or Braxton, who is Parker's age, has baseball games, and all his friends are at that same age. Our small town, there's 4 or 5 different baseball teams, all of their peers, and so he knows everybody. Would that be a possibility? Otherwise, I don't know where. I mean, his horse riding lessons is a private horse riding lesson thing, I believe, with Miss Terry Hall and Parker and Kirby.
Yes. Well, the horse riding lesson sounds like it'd be kind of an ideal time for you to
100%.
I'm going to leave Ms. Young in charge. I think if you want to make a suggestion to her, it's something that she need to attend also. And so I'm going to let both of you work with that. But the person who has final say is going to be Ms. Young for the next
Right.
one. Okay.
Okay.
Okay. All right. Again, I appreciate everybody's cooperation. Mr. Lawrence, thank you for your work. I need to pick a date to come back. So looks like that would be June 14th. And I wanted 9 a.m. Mr. Mills, I think, has a number of property financial issues he wants to discuss, but we're going to handle that on May 31. So it seemed to me the only thing in front of me today was a motion to waive the GAL fee. And I think I've already done that for Ms. Mills. So Mr. Mills, that's a motion you brought, is that right?
Yes, Your Honor.
Okay. Did we discuss what your income is in the past? And if not, can you let me know what it is?
I have filed a financial declaration previously that showed my income.
Okay. All right. I've got, you indicated monthly income of $24.72. Is that still about right?
Yes, Your Honor.
And expenses of $28.30. And are you working full time now, or is it seasonal?
Yes.
Or tell me about
it's full time, Your Honor. It's construction. I'm in an apprenticeship.
Okay.
And during the time of the year, the work slows down. So it's summer. So I do have more consistent work right now. And also, when the job is done, I will be unemployed until there's another job that my union can put me on.
Okay. Ms. Mills, do you have any comment on his motion to waive the GAL fee?
No.
Okay. All right. I'm going to go ahead and grant that motion.
Thank you, Your Honor.
Yep. All right. I don't think anything else was before us today, but I'll let the parties correct me if I'm wrong. Ms. Mills, do you think there are any other decisions today? Again, the property issues we're going to handle in 2 weeks.
I saw it was on the Odyssey that it was Tina Day's final review. So I guess I'm wondering when that is going to take place.
It's not with us right now. It probably was a date that I had put in the order, and if she was here, I guess we could talk to her. I'm not sure why she's not here, but I think she's still working with both of you, and that will come up.
Okay.
Hopefully she'll be here on the 31st and we can find out where she's at.
Okay. I do have one concern.
Okay.
I have a few, but I think I'll just stick to the one today. We have a mutual friend, and he has told this friend that it's concerning the protection order, that this is a temporary order and it just hasn't ended yet. And he's also mentioned to our third party that there's no distance in the protection order. So I guess I just want to make sure that he maybe goes and picks up a copy of this and understands that this is an order. It is not a temporary order, and to make sure that he's following it properly.
Okay. I will encourage Mr. Mills to do that.
I was also wanting to ask if we could enforce the right of first refusal. It's my understanding that my kids in Sam's time have been spending a lot of time with babysitters. I think that they are missing their parents, not babysitters. Sam is missing his time due to work or activities, and I'm missing my time with my kids due to Sam not allowing me to raise my kids and have that time with my kids. Tina Day has said that, there's no dangers at my home. I'm a stay-at-home mother. I don't see any need for our kids to be with a babysitter really at any given time unless one of us isn't available.
All right, before we respond to that, I think Mr. Mills should have a chance to consider that. I'm willing to put that proposal on the 31st also and address that. I don't know that I want anybody just having to shoot from the hip on responding to it. Okay. All right. Again, if you're going to talk about first right of refusal, we'll take that up in more detail on the 31st. But go ahead, Mr. Mills.
Well, in response to that, so the only time I have someone else watch them, and I don't do other activities, the only thing that comes in the way is work. And because it is summertime, I frequently have a Saturday shift that is typically shorter than my normal shifts. And our current plan is I pick them up Friday evenings and keep them through Sunday. So the only time that they are not in my care is in the morning to the very early afternoon when my mother, she stays the night Friday night, and I wake up early, I go to work, and then I come home, and then it's just me until drop off on Sunday. So they're not spending a majority of time with anybody but me. And it's just right now, because of the time of year, I need on Saturday that babysitter for a few hours.
And sir, again, I'm not making a decision on that today. I am. We're going to do that on the 31st. So I'll need to discuss that further with you on that time.
Oh, I am so sorry. I have one more thing. We had talked about a hair follicle test, and I was wondering if we could put a timeline on that, a date that he needs that submitted, because he admitted to using, illegal prescription drugs that were not prescribed to him in court. I believe it was March 1st. And so many days have already gone by that, 90 days, his test might come back negative. I'd really like a timeline soon on that if we could.
Will you have that done by May 31, Mr. Mills?
That's not a problem. Excuse me. That's not a problem. I need direction on what is acceptable, when and where. And that's what I've been waiting on this whole time.
Well, kind of a typical is to have you do a 12-panel hair follicle test. Columbia Wellness will do it. And that's where I would check.
Okay, and if they make me pay up front, you said that if it comes back negative, Rebecca will be responsible for that. So
right.
Okay, fantastic. Right. Thank you. I had a couple things I was hoping to bring up if there's nothing else to go over right now.
Okay, I'm somewhat late on my other docket, so go ahead and it may be something I'll say, let's take up on the 31st. And I'll try to call your case earlier so we have more time on the 31st.
Okay.
Go ahead.
Well, we've been doing pickup drop off in person. Rebecca has approached me and spoken with me. The Sunday before last, she approached me and said that she wanted to work together to do what's best for the kids, which is completely different than her attitude that she brings to court, which, as I've stated before, she's putting an act on to make this court or this case something it's not. And my last pickup on Friday, she allowed me to pick them up early from her house. And I did bring them back early on Mother's Day. So we kind of had that agreement with each other that I could pick them up early on Friday and I would bring them back in the morning so she could have Mother's Day with the children. And there has not been any issues with us meeting in person. So I just don't understand how that works with the anti-harassment order, because in court, she's saying she wants to do it by the books, but I mean, we haven't been, and she's been fine meeting me in person.
Okay, well, I think her cooperation doesn't really remove the order.
Right.
And
The order is anti-harassment. It's so that you can't say personal things about me. That's what the order is. And it's also maintaining a distance from me, aside from pick up or drop off with our children.
Right. That's the only exception. Okay.
And then I know we're crunched for time. If I may just throw in a couple things, I'm sure they'll be addressed at a later date. I do not like having to go through her boyfriend, the man she's trying to replace me as the father of our child, just to get information on my kids. I am perfectly okay doing a parenting app or just messaging her directly. I believe the reason she doesn't want to do that is because she doesn't trust herself to say something that wouldn't complicate her situation in this court hearing. And I think it's insulting that I have to speak to him to find information out about my children when we could go through a parenting app and discuss it with each other.
I did want to move away from that line of communication. Let's take that up on the 31st also.
Okay, can I just interject there and say that I offered multiple times to do a parenting app. We also went through his sister Angela, who said she no longer wanted to do it. She didn't want to be in between us. And then we went to another third party. So
Let's take it up on the 31st, please. Okay. Anything else, Mr. Mills?
Yes. Further finances to be discussed on the 31st. The bank is charging me nearly $500 a month that the Kia was not insured while it was in her custody. And I want to submit, when that is all squared away, I haven't gotten the exact number, but I would like to submit that and hope that she would pay what the bank has added to that car.
All right, you can submit whatever paperwork supports that, try to get it in by the 31st.
Thank you, Your Honor.
Okay. All right, thank you both. And on the 31st, again, I will call your case near the beginning so we have plenty of time to go over all these issues. Okay. All right.
Thank you, Your Honor.
2 weeks. Take care.